question.
Okay. I'm sorry.
Now this is what we do.
Give me 1 second. I forgot to write this on down. Count one. If I don't do that now, I'll forget. And this is Mr. Coleman on Roland Guillory. Good morning, you're Roland Guillory?
Yes, ma'am.
All right, this is 24 DCCR 1568, and
So we have an agreement except for one aspect that we
Okay.
wanted to ask the court about.
okay,
So the agreement is to plead him to a lesser included attempted endangering a child, misdemeanor, Class A misdemeanor, 2-year deferred probation, $500 fine, forfeit the weapon. He wants to have psych evaluation because he does have he has a diagnosis of bipolar. But then there was also no contact with the mother of his child and supervised visits with the child. So the case stems from his mother, meaning the child's grandmother, calling, stating that he made a statement saying he was going to harm himself and the child. So his mother calls the police. It is documented his mother was intoxicated at the time that she called the police, but so the police stop his vehicle. He lets them know he is licensed to carry. He had his gun in his holster. It was no belligerent scene, and so they removed the golden holster and took him into custody. It was, and so
just based on that, I think what I would like to do, a couple things. One, even though it's being pled down to a misdemeanor, get a PSI, which will
Okay.
give me more information that it can also have time to get the psychological evaluation done.
Okay.
And during that time, have supervised visits. And then all that may change, but I think to be on the safe side, just pending sentencing,
Okay.
have a no unsupervised time with the child. Are they still together?
No, this happened last year. So they co-parent. I talked to her last week. So she said she didn't want the no contact. So that was our issue. Because I talked to her and she was like, she doesn't agree with that because they co-parent well and she's in school. So he has the child while she's in school. But Mr. Coleman said he talked to her in June. And so she did tell me, she said, well, at the time they weren't on very good terms. So she might have told Mr. Coleman she didn't want. But now she said they are on good terms. And so that was our issue, you know.
I've got notes in my file contradictory. I'm not doubting what
She
Ms.
said,
Holmes'
yeah.
version is today, as we stand here today, but I have a different version based on my conversation back in August of 24.
Oh, that's a whole year
with the
ago.
complainant.
Okay, so the
And
August
she's
of
not the
24.
complainant. She had nothing to do with
She's
this
not.
case.
Well, mother of the child.
Yeah. So she had nothing to do, like she wasn't on the scene,
Well,
she wasn't.
Is she
Since
here?
we're doing a lot of
she's
this-
not.
Since we're talking a lot about extraneous things, judging what other people said and say, she did tell me back in August of 24 that the defendant has a history of being harassing and threatening with regard to her. So,
But you haven't heard anything since then?
no, ma'am.
And that was a year ago?
Yes, ma'am.
Can I say one thing, Judge?
Yeah.
I do get my son every other weekend since this incident has happened, so, and we haven't had any issues. I talk to my baby mother every day. My son actually started school this year, so that's.
But y'all aren't still in, you and the mom aren't in a
We're not
relationship?
together. We're more of like friends. We decided we couldn't be together.
I mean, the fact that it's been a year and they've been doing that, I feel like that's probably okay. So let's, but I do think even though, let's do a PSI though, but I'll allow things to continue as they have been. And then, have you been receiving any treatment for any diagnosis
I did
that
go
you?
to Spinal and I did get prescribed some medicine. I got prescribed some sleeping medicine, some bipolar medicine, and antidepressant medication.
And are you taking all that
No,
regularly?
ma'am, not currently.
Well, that causes me concern.
Yes, ma'am.
So,
I haven't been on it in more than 6 months.
why?
I'm having transportation issues getting back to Spindle Talk.
Okay. How do you get your child? And,
My baby mom will drop him off to my house.
okay, you're gonna have to go to, because of the nature of what you're saying that happened, and even though if she was under the influence, if there were some threats that had to do with that and some mental health issues, then within at least 4, and we can do as quick turnaround as possible on a PSI. I am going to have only supervised visits between now and then. You need to get back to Spindletop when you come back for sentencing. You need to show me that you are cooperating and doing everything and following any treatment that they say, because it's going to be a part of your probation now. So you need to figure out a way to get there. You need to figure out, they'll help you with medication, whatever it is. And I want to know what you're on, what you're taking, and that you are following through with everything, so that I know that you are in a good place, so that your child's in a good place, because we don't need to go back to what happened. So for now, you're going to be supervised only. So if you have someone that can supervise, great. If not, you just might have a couple of weekends that you go without, but we'll do it as quickly as possible. So let's go ahead and go through the plea then.
Yeah, because your mom.
Do y'all didn't do paperwork already though?
I have it here.
Okay, yeah, I'll hold it while y'all get that
So
done.
what
I'll
do you want
recall
me
it.
Because I didn't put as far as the agreed recommendation, him having no contact with his.
You don't have to put it as an agreed recommendation. I'll order it.
No
if you-
contact?
Judge, what I intended with the state, I recognize for the purposes of child exchange, there has to be some type of working.
Oh, yeah, I'm not worried about the contact with her. That doesn't seem to be an issue. It doesn't sound like that was an issue in the underlying part, so I'm not going to order no contact with her. I'm going to order supervise with the child, because it sounds like that is what the underlying offense had to do with, not her.
Okay.
So y'all can either agree to mark it off, or I'll do it when it comes through. If you want to argue for it, that's fine, Mr. Coleman, but no, I'll allow him to have contact. You can have phone conversations with your child. You can FaceTime between now and then. I just don't want if there's a supervised, y'all could if you can go somewhere, go to McDonald's, meet her there, have breakfast or lunch or something. No unsupervised. So I'm not saying you can't see them, but you just have to have somebody appropriate supervising until I get some more information. Does that make sense?
Yes, ma'am, it does.
Okay, and it can be her. If y'all are getting along, it sounds like that's not an issue. But I would say it's not going to be at her house. I want y'all to be somewhere public. That's not a good idea. Okay.
Yes, ma'am.
Y'all go take care of that paperwork, and
So
I'll
what
take
do
care
I-
of it. Y'all.
What do I put? Do I put as a condition, as a probation condition, supervise it, or?
No, because that's going to be a bond condition.
Yeah.
I'll say it when y'all come back up.
Okay, so I won't write it in. Okay.
Yeah.
I guess if I go.
Just have a seat. Yeah, sure. Y'all can go over that paperwork, and then I'll
Okay, I
recall it in just a minute.
This is the forfeiture.
Okay, I just didn't know if you want to hold on to it.
Yeah.
Okay.
I just sent it to you.
Good morning. Are you Carl Ross?
Yes, ma'am.
And Mr. Ross was previously in court and entered pleas of guilty in cause number 25 DCCR 0093 and 0094 to the second-degree felony offense of collision involving death and the third-degree felony offense of collision involving serious bodily injury. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor. Yes, Your Honor, we have.
Are there any additions or corrections?
No, not from the state, Your Honor.
Mr. Ross, are you still working at TAS?
Yes, ma'am.
Okay. All right, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. Find sufficient evidence in each case to find you guilty. However, I'm going to follow the agreements that you made with the district attorney. In cause number 25, DCCR 0093, I'm going to defer all proceedings and place you on probation for a period of 10 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. In cause number 25, DCCR 0094, also defer all proceedings and place you on probation for a period of 10 years. Order you to pay a $1,000 fine and to follow all of the rules and conditions of probation. I am going to order, but hold in abeyance, 180 days upfront time in each of these cases. And what that means is that if there is anything at all that happens at the beginning of this probation where you're not following the rules or anything at all that probation feels like isn't going according to the plan, then I have already ordered 6 months in jail upfront time. The seriousness of what happened and what you did and the fact that you left is just, it's awful. And so The fact that you're working, I think it's important that you continue that, but I'm not going to worry about that at all if you're not doing everything perfectly on this probation. Do you understand? If you follow all of the rules and conditions of probation and you do everything that you're supposed to, the opportunity that you're being given today is huge. You're not going to have these felony convictions on your record. And at the end of the cases, if you successfully complete the probations, the cases will be dismissed and you'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you will be brought back into court. You can be found guilty of both of these offenses, and in one, you could go to prison for up to 10 years and the other for up to 20 years. Do you understand? I'm handing you in each of your cases the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up when she's ready to go over your paperwork. Good morning, you're Donald Owens?
Yes, ma'am.
And this is 24 DCCR 1192. Mr. Owens is charged with sexual assault of a child, set for trial to begin with jury selection next Monday. And what is the announcement?
Stay true.
All right, then I want to make sure that y'all all understand, obviously after today, no plea agreements unless there is something that comes up very quickly that I'm not or y'all aren't aware of. It is likely to be towards the top of the list since the other old one is gone now. So stay in touch with Mr. Kelly. He'll let you know when you need to be back next week. Okay? All right, you're free to go.
Thank you.
Thank you. See, Mr. Lewis, you have Naquindon.
He's right here.
Oh, there you are. Naquindon Aclese.
Yes, Judge.
Good morning. Are you Tate Daly?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Please hold on.
Let's see, we're going on 179. Mr. Daly, in cause number 25 DCCR 0179, you're charged with the state jail felony offense of driving while intoxicated with a child under 15 from September 2nd of 2024. And how do you plead to that charge? Speak up.
Speak up.
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 2-year term in state jail prison, but that would be probated. You'd be on probation for 5 years. You'd be ordered to pay a $1,000 fine, follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
In addition, as part of this plea, the state would dismiss cause number 25 DCCR 0180. Is that also your understanding?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
Without objection.
It's admitted. Is there any evidence that Mr. Daly's not competent?
There's none, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you are mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back at a later date for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. All right? Well, yes, sir.
And Your Honor, for the court's information and also for the record, the endangering case under cause number ending in 0180 is not only being dismissed as part of the plea in this case, but also because it is the underlying facts are the same as the DWI.
Okay, perfect. Thank you. I'll sign that dismissal. Looks like it's already come through. So just stop and talk to probation on your way out, okay?
Yes, ma'am.
Yeah, okay, thank you. Good morning, sir. You're Mark Garcia?
Yes, ma'am.
And Mr. Garcia, did you get someone hired?
No, I didn't. I can't afford it. I just need a little more time to get the money together.
Well, who'd you talk to?
I talked to like work and all things. Wilkerson, Marcus Wilkerson. And then I talked to Willard, James Hall Jr.
Speak up, please, I'm
I
sorry.
talked to Willard, James Hall Jr. and Marcus Wilkerson. And then Leanne Johnson. I tried a couple ones, but I left some voicemails, but I haven't heard back yet.
Okay, so what I can do, Mr. Garcia, you've been coming for a few months. If you, since you did what I asked, you can fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. If you make sure you fill it out accurately and completely, don't just leave it all blank or put zeros. You're going to swear under oath that it's all true and correct, and then I'll take a look at it. Step in front of the clerk, and she'll give you that. Good morning, sir. How are you? Good morning. You're Glenn Hicks. And Mr. Hicks was previously in court. This is cause number 25 DCCR 0369. Entered a plea of guilty to the third-degree felony offense of assault family violence by impeding breath or circulation. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Any additions or corrections?
No, Your Honor.
All right, Mr. Hicks, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have the felony conviction on your record. And if you successfully complete the probation, at the end, the case gets dismissed. The other side of that, though, is if you violate any condition of probation, when you come back, you can be brought back into court, found guilty of the offense, so you would be a convicted felon, and you could go to prison for anywhere between 2 and up to 10 years. You understand?
Yes, ma'am.
I want to make sure you understand that you are also, part of your probation is not to have any contact at all with January Corpus. So I don't know what the status of that relationship is, but it's over if it's not already. She cannot give you permission to violate this order, okay? So she can't say, it's okay, I want to get back together, or anything like that. You cannot contact her in person, you can't have communication on your phone or Snapchat or whatever it is. Do you understand?
Yes.
Okay. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to just have a seat here in the courtroom. Probation's going to call you up to her desk when she's ready to go over all of your paperwork. Good luck to you, sir. Let me see. Good morning. Are you Christian Kane?
Yes, ma'am.
Okay. We're going to lesser.
Yes, Your Honor.
This is cause number 24, DCCR 1947. I am going to take judicial notice of the court's file, including Mr. Kane was previously found not competent to stand trial, sent to the John Dunn Behavioral Science Center for competency restoration, received a packet from them dated September 15th of 2025. It includes the attending physician's report to the court from Dr. Liberis with the opinion that he is currently competent to stand trial. In addition, there's a trial competency evaluation report that was prepared by Dr. Robinson. Also has the opinion in that Mr. Kane is currently competent to stand trial. Is there any other evidence with regard to competency?
No, Your Honor. No, Your Honor.
All right, then at this time, based on the 2 reports, I am going to find that Mr. Kane is competent to stand trial. Mr. Rojas, will he waive the formal reading of the indictment?
He will, Your Honor.
Mr. Kane, in cause number 24, DCCR 1947, the state's elected to proceed on the lesser included offense of a Class A misdemeanor evading detention, and that's from August 9th of 2024. And how do you plead to that charge?
Not guilty.
Okay, and are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, I did.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, Your Honor.
And are you a U.S. citizen?
Yes.
State tenders number 1.
No objection.
It's admitted. All right, Mr. Kane, I'm going to find again that, find that you entered your plea of guilty freely and voluntarily. Find again that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the lesser offense of a Class A misdemeanor evading detention. Sentence you in accordance with your agreement to a term of 90 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you've waived your right to appeal. All right, good luck to you, sir. You can go back with the bailiff. Morning, sir. Is it Morrell or Morale?
Morrell, actually.
Morrell. I was all wrong. All right, Mr. Morrell, did you get someone hired?
No success. I've been to 4 different attorneys.
Who have you talked to?
I've talked to James Macon, Mel Shalander, and J.T. Haynes.
Okay.
And the 4th one was Miss Barrazo, I think. I don't call her and everything, but she was in court, so I didn't actually have
Gotcha.
contact with her.
Okay.
Yes.
And so are you working?
I'm working, yes, ma'am.
Where you work?
Monroe's Cleaners.
Okay. And so as far as being able to afford or saving up, are you trying to work towards that?
I'm working toward it, but no success because I have an excessive amount of bills to pay, and I can't split the difference.
So what I'm going to do this morning is have you fill out some paperwork to see if you qualify for a court-appointed lawyer, since you did what I asked you to do.
Yes, ma'am.
Make sure you fill it out accurately and completely. You're going to swear under oath that it's all true and correct, and then I'll take a look at it.
Yes, ma'am.
If you step in front of the clerk, she'll give you that paperwork.
Thank you.
Yes, sir. Good morning. Are you Maria Garza?
Yes.
And Ms. Garza, this is your initial appearance in cause number 25 DCCR 1008. You're charged with a second-degree felony offense of aggravated assault with a deadly weapon, and that's from June 15th of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
I wish that they had gave me attorney Hogan.
Right, and so while you're in custody, we automatically give you a court-appointed lawyer. But now that you've bonded out, I'm going to expect you to try to hire your own lawyer.
Okay.
So what I'm going to do is reset your case for about 30 days to give you some time to try to hire someone.
Okay.
If you get someone hired before that next court date, bring the reset notice that you get today to that lawyer and they'll tell you what to do.
Okay.
If you're unable to hire someone before the next court date, I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would have to go back to jail. Do you understand?
Yes.
All right, step in front of the clerk right here. She'll give you a reset. Just sign this first, and then you can grab it on your way out. Good morning, sir. Are you TJ Landry? Yes, and will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Landry, in cause number 24, DCCR 0165, you're charged with the state jail felony offense of theft from a person from December 9th of 2023. And how do you plead to that charge?
Yeah, showing me no contact.
You either did it or you didn't do it. Are you guilty or not guilty?
Yes.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? Speak out loud, please. I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
It looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $300 fine, and you would be required to follow all of the rules and conditions of probation. Do you understand?
Yes, ma'am.
And is there any restitution?
No, the shoes were recovered that
Okay.
day.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Landry is not
No,
competent?
Your Honor.
And Ms. Malfino, with regard to waiving pre-sentence report, is there any issues with regard to history I need to?
No, Your Honor, it looks like there may be some misdemeanor contact, but he has no felony history. I have no objection.
All right, so what I'm going to do, Mr. Landry, is waive the pre-sentence report. I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for a period of 3 years. You're ordered to pay the $300 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And if you successfully complete the probation, at the end, the case is actually dismissed. You'll never be a convicted felon. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, you could be found guilty of the offense, and you could be sentenced to the state jail prison for up to 2 years. Do you understand?
Yes, ma'am.
All right, I've handed you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. In just a few minutes, probation's going to call you up to go over your paperwork. She's sitting at that desk right there, so watch for her to call your name, okay?
Yes, ma'am.
Good luck to you, sir. Yes.
Sorry to interrupt.
Hang on.
Just, since we're waiving the PSI, may I ask to request of the court that one, he be trespass warned from Parkdale Mall, and that he not be allowed to have any contact with a Jalen Nixon or Reginald Guillory?
All right, so I'm going to order as a condition of your probation, Mr. Landry, that you are not allowed to go on the premises of Parkdale Mall. That'll be a part of your probation. Also, you're to have no contact or communication with Jalen Nixon and tell me the other name?
Reginald Guillory.
Reginald Guillory. So that means in person, y'all can't hang out, but it also means any other way. You can't send messages, you can't Snapchat or DM or anything like that. You go live your life, and whatever they do, they need to live theirs. Make sense?
Yes, ma'am.
All right, you can have a seat. Thank you, Ms. Malfino.
Ready? We want to try here. We'll take a list.
All right, sir, you're Tejuan Mack,
Yes, ma'am.
and this is 24 DCCR 1046. Mr. Mack's charged with criminally negligent homicide, set for trial to begin with jury selection Monday, the 29th. And what is the announcement?
That's right.
State's ready, Judge.
All right, I do want to make sure that after today, y'all understand that I will not accept plea agreements.
Understood.
And it's likely to be pretty high up on the list, depending on the other cases. Mr. Mack, you want to go forward with your trial on that date, is that correct?
Yes, ma'am.
We
Okay.
requested a speedy trial.
Well, it's
I understand.
set in 2 weeks.
I know, but as far as the trial order, we have requested this.
I understand. The other case, though, is a child case, which would take precedence if that one in fact goes, but this likely to be probably the first backup to that, potentially. So
So you
we'll
want
see
him-
what else I
I
have.
You
think
want
there's
him-
Batiste on there, Judge. I think he may be in custody.
Oh, he is.
It's somewhat of an old.
It is actually. So here's the thing, I will number the cases tomorrow. Stay in touch with Mr. Kimmler. He'll know tomorrow after my docket what the trial order is and when you need to be back. Okay? All right. Good morning, you're Marquise Berry? Speak up. And Miss Berry, were you able to get a lawyer hired? That's right, right over now. Okay. So what this says is that you don't have any complications that would require you not to work with some certain parameters. So you're not on bed rest. For who? Have you tried?
I was working at Orange's Hospital before. I had stipulations. And let me come due to the fact that I had all those stipulations.
Okay. All right, so I'm going to have you fill out some paperwork this morning, Miss Berry, to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely because you're going to swear under oath that it's all true and correct. Step in front of the clerk down there. She'll give you that paperwork. Okay, we're going on a lesser. And this is Mr. Coleman's on Deshauna Bass. Good morning, you're Deshauna Bass? And will she waive the formal reading of the indictment?
She does, yeah.
And Ms. Bass, in cause number 24, DCCR 2316, the state has elected to proceed on the lesser included offense of a Class A misdemeanor assault from October 27th of 2024. And how do you plead to that charge? And are you pleading guilty freely and voluntarily? And because you did what they've charged you with. I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 2-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes.
And are you a U.S. citizen?
Yes.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Ms. Bass is not competent?
No.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney. Defer all proceedings and place you on probation for a period of 2 years. You're ordered to pay that $500 fine and to follow all of the rules and conditions of probation. If you do that, this is a great opportunity because you don't have a conviction on your record. And at the end of the probation period, if you successfully complete it, the case is actually dismissed. You'll never have a conviction. The other side of that, though, is if you violate any condition of your probation, you can be brought back into court, found guilty of the offense, and sent to the Jefferson County Jail for a period of up to 1 year. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation's going to call you up in a few minutes when she's ready to go over your paperwork. She's at that desk right there, so be watching for her to call you up, okay? Good luck to you, ma'am. Thank you.
Thanks, Judge.
Thank you.
And your signature's not on that.
Yes, ma'am.
Good morning, sir. You're John Martin?
Yes, ma'am.
And Mr. Martin is charged in cause number 25, DCCR 0583, with injury to a child, elderly, or disabled individual. And Mr. Burbank, what is the announcement?
I believe the state and I are looking for some CPS workers. Is that right?
I don't see that there's been an order for those yet.
There hasn't, Judge. I'll get one filed. I needed to talk to Mr. Burbank to see if he already has one. He does not, so I'll be sure.
Okay, yeah, let's get that done quick because it takes a while, it seems like, on some of those. I'll sign that order as soon as it comes through. Let's go ahead and just do a 60-day reset because obviously it'll take a little time once I sign that for those to come in, but hopefully they'll come
They
in.
may have them over on the civil side, upstairs.
Okay, all right, yeah, if we can get them that way, that'd be great.
If not, I'll reach out to Miss Adams. She
Okay.
usually gets them to me
She
pretty
is.
quick.
Thank you. All right, Mr. Martin, stay in touch with Mr. Burbank. He'll let you know when you need to be back. You're free to go, sir. Yes, thank you.
Thank you.